Is this email that you see in AG 423 a fair and accurate copy of the email that you received from Ken Paxton on February 8th of 2023?
Yes.
At this time, Judge, I would offer AG Exhibit 423 into evidence.
Any objection?
Yes, Your Honor, I have three objections. First, it was never produced. Second, it was listed on their privilege log, so it was never produced. And three, it's hearsay, so it is inadmissible.
I can address the objections. I didn't hear your second objection. Could you repeat that?
Yes, this document was identified on your privilege log, so you never gave it to us. And now you're bringing it to court for the first time and showing it to us for the first time.
Let me address the privilege log first. As an attorney for Ken Paxton, I think at this time we'd be willing to waive any privilege.
I appreciate that, but the fact
I'm not done, and if I could just finish my response, then I'd be happy to be quiet and let opposing counsel go. So first and foremost, as Ken Paxton's attorney, I'll waive the privilege. With regard to hearsay, it's not offered for the truth of the matter asserted. It goes towards the effect on the listener in the mediation the next day. We heard Mr. Dorfman just state that on the record. And his first objection with regard to it being not being on the witness list, or excuse me, the exhibit list, Judge, this is a rebuttal case at this point, and arguably we don't even have to put a case on. Most of our exhibits are rebuttal exhibits, but we did give them a list. I am arguing that this is a rebuttal exhibit, and for that reason, it is not covered by the exhibit list rule, and it should come into evidence.
Your Honor, may I respond?
Yes, you may.
Just so we're clear, the process that occurred was they produced a privilege log, never gave us this document, and now for the first time they're sandbagging us with this document without giving it to us. As the court is aware, you have ruled several times that documents that we did not produce would not come into evidence. They never gave this document to us. This is the first time we're ever seeing it. If they want to take every document off their privilege log and put it into the record, we're good with it. Otherwise, we have a valid objection. Second, Your Honor, it is clear hearsay. There is no business record. The predicate laid was not the standard for hearsay, and so it is inadmissible on all of those grounds.
If I, and just brief, yes, Judge. Well, I'm not aware of a privilege log that we came up with or provided to the House Board of Managers first and foremost. This was on our fourth supplemental notice of the exhibit list. I think the court is aware that the managers have given us plenty of exhibits throughout the course of this trial. I mean, if I remember correctly, Mr. Bangert dumped text messages between him and the Attorney General during the middle of trial. So to say that I'm sandbagging them is just simply not an accurate reflection of what's going on throughout this case or with regard to this exhibit.
Okay. I've heard both arguments. Give us a moment.
Andrew, just react to this.
Well, once again, we're in a situation where you've got a hybrid proceeding that's sort of part criminal, part civil, and
Part whatever,
part just made up. And so, but apparently part of the rules were that you had to turn over what you were going to have to the other side. And if they had a privilege log and this document was on it, and then now all of a sudden they're pulling it out and trying to admit it, I mean, I don't know what these guys are doing. And also, this witness is just so boring. I wish they would move him along.
Yeah, this witness, well, and you know, I actually covered the settlement situation, and my recollection, based on what I was told back at the time, was that it was actually what Brickman described, that Paxton's side reached out to start the settlement negotiations.
That was always what I heard.
And Dorfman is testifying to the exact opposite. So that's very interesting to me. You know, that's a factual question now. Who started? I mean, because it becomes an important point, right? In a way, because the point that Brickman made was that settlement negotiations weren't initiated until after the election, right?
Yes.
And so he's saying the exact opposite. So, you know.
Well, and once again, I go back to the fact that there's pending litigation. These cases are not settled, and to put all this stuff out there in sworn testimony, I just don't think it's a good idea.
Can we settle who
started? I mean, is it going to rest as his word against Brickman against Dorfman? Is there something that's going to resolve that?
I don't know.
We don't know. We'll have to wait till cross to see if the other side has any.
And that could also come
Anything in
out
writing.
I mean, you know, like she said, there's still a pending lawsuit, and it could come out in that lawsuit later.
Well, there's been what I would think were, or what sounded to me like a lot of disparaging comments coming from some of these AG witnesses against these whistleblowers who have this pending civil litigation against them. I don't know. I don't understand why they're doing that. I would not be touching it. I understand it's an article of impeachment. I just think you could have gone around it without throwing more aspersions on these people, which is what they've been doing.
Well, I mean, they're trying to attack that particular article, and they've been working on it, almost, the whole afternoon and part of the morning. And it seems like that is an article that they feel like is very, very important to them to bring down, and very important to mount a defense against. They're working on the whistleblowers themselves and their credibility.
Oh, well, he's hammering.
Okay, let's take a listen.
Got the big hammer.
Jurors, please take your seat. After consultation with my team here, we will sustain the objection on hearsay.